Hello again, this is JJ Minioza, shareholder with the Oakland East Bay office of Erickson Arbuthnot, and I'm here to talk about the basis for attorney's fees in habitability cases. Now, as we often talked about before in other instances, because the risk of exposure to attorney's fees is so great, we should understand the basis for attorney's fees awards in habitability cases. In California, attorney's fees are an item of recoverable costs that can be awarded to a prevailing party, as opposed to damages. And the standard for determining whether a party is prevailing is a pretty low standard in California. And generally, the courts have found that any party suing for economic or monetary damages who recovers a quote net monetary recovery is considered to be prevailing. And the implications of that are pretty significant because any net monetary recovery can include even nominal or minimal amounts. And if they can recover, if they do recover a nominal amount, they are considered to be the prevailing party and can recover all of their attorney's fees as a cost. And oftentimes in habitability cases, the damage exposure is relatively limited, but the recoverable fees can often dwarf the recoverable damages, sometimes exponentially and sometimes by huge factors if the court decides to award a multiplier to the attorney's fees award. And the other source of attorney's fees is by contract or by statute, costs being awarded to a prevailing party. In habitability cases, tenant plaintiffs can recover attorney's fees if the lease agreement also contains an attorney's fees provision. This can be the typical or customary standalone attorney's fees provision, which usually has language to the effect that attorney's fees are awarded for any conflict or dispute that arises from a party's breach of the lease. But these we find are becoming more and more uncommon, in fact, are rarely seen in residential lease agreements. Or, more broadly, attorney's fees can be found from lease provisions where they mention any type of attorney fee recovery, like an indemnity provision or a tenant holdover provision, which typically awards attorney's fees to the landlord. But there is case law and specific statutes in California that find that these attorney's fees provisions would be reciprocal and therefore form the basis for an attorney's fees award for the tenant. A tenant plaintiff can also recover attorney's fees based on a statutory violation, such as a municipal tenant protection ordinance or the California Civil Code. And tenant protection ordinances, which we find in larger cities typically, such as San Francisco, Oakland, and Los Angeles, are often very pro-tenant in their provisions and often contain harsh penalties for landlords who are in violation. And again, not only attorney's fees can be awarded in these tenant protection ordinances, but statutory penalties and even treble damages. And the California Civil Code itself, although it's not pro-tenant in its language or its nature, the primary source of attorney's fees is where a landlord is cited by a public agency for a habitability violation and fails to abate the violation within 35 days. That's it for this session. We'll see you next time.